Hey, you have Patrick Findaro here, co-founder of Visa Franchise. Excited to have on Brian Getson, immigration attorney at Getson Schatz. We've been working together, I don't know, maybe 6, 7 years. That the first case way back in the day was E2 Visa, and I think it was probably through Brian I learned about the EB2 NIW 7 years ago before we started helping people this year with the NIW. So we're going to talk all things EB2 NIW. Brian's definitely one of the top immigration attorneys in this field overall for immigration law, but especially this subset of immigration with EB2, EB1A. Brian, thanks so much for joining today.
Yeah, thank you so much for having me, Patrick. I'm very excited to be here and to help everybody learn about, the secrets to getting your NIW case approved.
Let's just set the pretext. I don't want to speak for you, but like, could you give an estimate of how many EB2 NIWs, how many I-140s you've had approved over the years?
It's thousands, Patrick. I mean, I've been practicing law for 28 years now, and we really specialize in these types of self-sponsored immigration petitions. So, I have a really good sense of how to present cases to immigration, what evidence to prepare, how to write letters, and just a good pulse on how the immigration service is deciding cases.
I think your firm's like operations and focus is pretty in line with what we're doing at Visa Franchise, where it's all about taking control of your own American dream, whether it's through your own startup business, through buying a franchise, or it could even be, us supporting with the personnel plan for the EB2 NIW.
Absolutely. If you are able to not be bound to an employer, then that opens up a lot of opportunity for you, both in terms of having your own business, being able to change jobs without having to start over with a perm labor certification application, and also being able to apply from outside of the US without any particular offer of employment. So the NIW is really special in terms of giving you control over your own immigration situation.
Brian, what are some of the key criteria for those seeking the EB2 NIW, and how can applicants demonstrate their work, their proposed endeavor, is in the national interest?
Sure. So the NIW is governed by a case called Manor of Danasar. And that's an administrative appeals case that sets forth what the legal standard is for national interest waiver petitions. And then the Immigration Service has a policy manual. If you Google USCIS NIW policy manual, you'll find that. And in the policy manual, it sets forth the legal standard of Danasar, and it talks about, what immigration is looking for, what types of evidence, etc. So there are three prongs in the Danasar case that you have to meet in order to get approved for a national interest waiver petition. And also, you have to have the equivalent of a master's degree or higher. So you either have to have a master's degree or its equivalent. An equivalent under the immigration law is a bachelor's degree plus 5 years of progressively responsible experience. So you have to have that advanced level degree or its equivalent, and then you need to meet the three prongs of Danasar. So the first prong is that your work is of substantial merit and national importance. And for most people, your work is going to benefit the economy of the United States. It could also possibly benefit the environment, healthcare, education, basic science is good enough, when it comes to substantial merit and national importance. So that's the first prong. And then the second prong is that you're well positioned to advance your endeavor. So that is, what are you going to be doing in the United States? And that's where, Visa Franchise is really excellent in terms of helping people establish a business in the United States, a business plan in the United States, sort of telling immigration what you're going to be doing. I always joke that, if they give you a green card, they want you to keep working in your field. They don't want you to drive Uber or deliver packages for Amazon to eat. So, you have to really be clear that if you're given a green card, you're going to keep working in your field. And then
And
you have to show,
I've heard there could be issues at the citizenship stage where, well, you came to the US to do this, and now you're not doing anything, and you're trying to
yeah,
get
I
a
mean, as
US
long as you
citizenship.
work, so you're defining your field of work to immigration in the national interest waiver petition. You say, I am, going to work in the field of blank. And you are the one filling in the blank, telling them what you're going to do. So you're in control of that. You're in control of that in terms of the business plan, your personal statement, etc. And you're not expected to do that forever, but once you get the green card, you for a reasonable period of time, you should be working in your field. So, you have the plans for work, and then the part two of the DANISAR is also about your credentials. So, what have you accomplished in your field that, is going to translate if they give you a green card in the US, they know that you're already accomplished in your field. So they believe that you're going to keep, being accomplished, that you're going to contribute to the United States. And then the third part is basically that on balance, we're not going to care about US workers. That what you have accomplished in the past is, impactful enough on the field that we don't worry about US worker availability, that you're an accomplished individual in your field. And that sort of becomes the totality of the circumstances test. They're looking at, well, how are you going to benefit, the economy? Are you going to create jobs? What are you bringing to the US? And then are you accomplished enough that it's what they call sufficiently urgent, that they're not going to make you go through this labor certification process and worry about US workers? So those are the three prongs. And then you get into, well, how do you meet each of the three prongs?
And we've crafted our service to kind of adapt because it's, we've had clients that are going to be employees. We've had clients that entrepreneurs going to open up their own business, as well as kind of hybrid. They're going to be consultants for multinationals, different companies, and effectively they are an entrepreneur. But it's kind of in that first month of working together, what makes the most sense for you to be doing your work in the United States at the highest level, as well as meeting the criteria for the EB-2 NIW.
Correct. So if you're outside of the US and you're looking, to apply for this NIW, well, you have, like you said, there's different options. So option number one is there a way for you to come to the United States first in a non-immigrant status? If you're already here in the US and already working in your field, then it's easier to convince the immigration service that if they give you a green
The
card, you're working
proposed
in your
endeavor is the endeavor. I am doing this,
correct.
and I will
Exactly.
continue doing this.
Exactly. So that is choice number one. That's at the top of the list. Can you
You're
come
already
here?
doing
Can you
it. It's
get,
easier for everyone.
right? Can you get an E2 visa, a TN, an H1B, whatever it may be? Then if you can't do that, and it's obviously hard to do that, then choice number two is you would get somebody in the United States to say, we would consider hiring you if you had a green card, right? It's like, they're not committing to anything, but it's showing that, here's my plan. My business plan is to join this company. They would consider hiring me if I had a green card. So at least that shows immigration something tangible. And then if you don't have that, then you say, immigration, I promise you I'm going to work in my field if you give me a green card, but here's my business plan. And that's where Visa franchise is, really wonderful in terms of outlining what's your business plan going to be. Is it going to be having your own company and being a consultant? Is it going to be, working for a company? And the business plan, it talks about basically what your skills are and what you're planning to do and how that's going to be beneficial to the United States. And then if you can get some potential customers, clients, etc., in the United States to write a letter, hey, we are interested in the skill set that this individual has, we would be interested in them consulting for us or working for us or whatever it may be, then that is very, very helpful. So when you're presenting evidence to immigration for in terms of what you're going to do, those are the different paths.
And it reminds me a little bit of, because we have far deeper experience with some of these investor cases, but them actually doing everything. And, we open up the company for those consulting clients and entrepreneur clients, get the business bank account, get the licenses in place, and then get the letter from the client, or start servicing the client in a legal manner that doesn't violate, immigration law, and actually providing some services. And I'm sure that would make, it a little easier putting the petition together. No?
Yeah, absolutely. So you're putting the petition together with letters and with evidence. And everybody's case is unique and different. And you have to brainstorm in terms of what letters to provide. But you have to think that different letters are trying to make a different point. So you're going to have letters from your supervisors, right? Your supervisors, in your career, are going to talk about what you have done and how it has been impactful. But your supervisors, everybody knows they're going to say nice things about you, right? If you had the lawyer in the office next to me
Or they
write a
want to do
letter,
the letter, period.
right, they're going to say I'm great. So we know that your supervisors are going to say nice things about you. Then you need your own personal statement about what you're going to be doing. And then what other letters can you obtain? So if there's a customer or a company that has benefited from your work in any way, then you should try and get a 1 or 2 page letter from them talking about how your work has benefited them. Then we talked a little earlier about, is there any prospective customers or clients in the United States that could talk about how you would help them? Then, is any of your work in the public? A lot of times that's not the case, but sometimes it is. Sometimes maybe you have written an article, or maybe there's been an article written about you, or maybe you have published something, like made it publicly available online that anybody can access. So if any of your work is public that anyone could know about, you want to get what we call independent experts to write about your work that is public. So all of these different letters they're trying to show that your work has impacted the field. It's been influential. You've made a difference. You're accomplished. And you're going to bring all of that skill and experience and accomplishment to the United States to benefit. So that's the letter part of it. And then there's the evidence part of it. So again, if anything is objective, right, that it's helpful. So that is, have you published? Is there an article about you? Is there anything that anyone could know about? Do people randomly reach out to you? Does anyone contact you on LinkedIn, by email, to ask you for your advice or expertise or to do something? Now that is showing immigration other people consider you an expert, so immigration should consider you that expert also. So, and that's something that people don't always think about in terms
I
of,
wouldn't have thought about it, but it makes sense. How many letters would you say on average? And I'm sure it's quite a big range. Like, is the typical applicant gonna have in their package?
Sure. So I'd probably say about 10 letters is the average. And again, it's making a point, right? Each letter is geared towards proving something. So, that's sort of how we go about doing it. So once we have the letters and we have the evidence and we have the business plan, and maybe you have if you're going to be a consultant, you have the corporate plan also, then we do a detailed cover letter to immigration, and we're going over the different DANISAR points in terms of DANISAR 1, the substantial merit and national importance. And what we typically do is we give background information. So whatever field you're in, if you're in the oil and gas field, we're going to find articles online about oil and gas. We're going to, show why the US government is interested in that. Or if you're in the artificial intelligence field, or, whatever it may be. So you want to give documentary evidence to indicate exactly why your work is of substantial merit and national importance. Again, it's one thing for you to say it, it's another thing for you to show it. And, if you're in a STEM field, if you have a STEM degree, then there's all kinds of initiatives from the White House. There's a list of critical skills and technologies, and we will reference that and talk about how you're benefiting it. And then in the DANISAR 2, we sort of summarize what your career accomplishments are, give a summary of the letters, have quotes from the letters about your accomplishments, and also put the evidence into that part. And then in DANISAR 3, we sum it all up. We say, here's the benefit that you're going to bring to the US if you have a green card.
And Brian, I mean, it wasn't that long ago that this was just like from what I understand, a visa for researchers, doctors. I know January 2022, USCIS issued that guidance and gave clarification for people with advanced degrees, STEM, science, technology, engineering, and math, as well as entrepreneurs. But from what I understand, and my friends at EB-2 NIW's year back, they're all doctors that got the EB-2 NIW. I've met actually a couple of researchers too. Can you tell us a little bit about that shift and what happened that made this visa category go from what might be 5,000 people a year to what should be 20,000 plus in this fiscal year?
Absolutely. So that's exactly what it was. It was a shift in the policy guidance. And we had mentioned earlier to Google NIW policy manual. And, there's a shortage of skilled employees in the United States. And, it's very hard from a political standpoint to get any new laws passed, right? To get Congress to do anything on immigration is basically impossible.
What's it been, 40 years since there's been a major shift?
The 1990s is when, there's really been a change in immigration. So the way that they can sort of make it more open is to adjust the regulations. Within the context of the law, you open up the ability to apply. So, and the biggest difference is exactly what you said. They made it more viable, less restrictive for people with STEM degrees and for entrepreneurs. And there's a whole section in the policy manual discussing what they're looking for from entrepreneurs. Do you have funding? Are you part of an incubator? Are there customers that are interested in what you're doing, etc.? So, a lot of times, this is the only way for somebody to try and come to the United States. They don't have enough money to do an investor visa, or they're not from a country that is on the E2 list. They can't go through the H-1B lottery because they don't have a company to sponsor them. And there's a, 15 to 20% chance of winning the lottery. So when something is the only way, then you take your shot, right? You throw your dart at the dartboard because it just might work. And that's where if you're creative and you have the resources, that Visa franchise can bring, that a lawyer can bring in terms of a business plan, writing letters, case preparation, organization, putting it all together, then you have a shot at this. So people who would have never had an ability to come to the US before because they're, a computer engineer, or they're working for a company and they haven't published like a researcher, they haven't presented, there's no peer review, there's none of that. Well, you don't need any of that anymore to get a green card in the US.
Tell me about your team and the writers, because I had friends again that did the EB-2 NIW that kind of complained about the process, where it was like I had to do everything. I had to draft the letters. I had to chase people down. I didn't know what should be in the letter, going back and forth with the attorney. And a lot of times it was the same law firm that they use for the H-1B that might not really be specialized in this category. But tell me about your process and how you really help with those 10 or
Sure.
so letters that are going to be presented.
Us, we're specialized in this. We have a unique structure to our law firm. So we have 15 what we call science writers. And they all have either bachelor's or master's degrees in a science background.
Hmm.
And all that we do is prepare NIW, EB1A, and EB1B cases. So we have, our firm is set up to do this. So the way that the process works is, the first thing that I would do is I would send a client sample outlines. And I would say, tell me your career accomplishments. Choose a sample that you like, that you're comfortable with, and tell me what you have accomplished in your career that resembles this sample. And usually samples from scientific researchers give the best structure. So the first thing that happens is the client outlines everything they've accomplished in their career in chronological order. Then after I get that outline, I ask questions to make it more simple and understandable. I'm not an expert in artificial intelligence or, mining engineering or whatever you may be doing, right? So, and nor is the immigration officer, right? So we have to make it simple and understandable that the immigration officer is going to be able to read your case and understand exactly what you do and why it's important. Then after you answer my questions, we write every single letter for you. And I'll also brainstorm with you about the types of letters, right? So we're going to write all these different types of letters. We're going to, decide who's going to write the letter, what the letter is going to talk about it. And then I write every letter. And then I'll give it to the client. They'll edit it with track changes from Microsoft Word. We then finalize it. Then we use a secure file sharing service called Basecamp. And everybody uploads to Basecamp the letters plus the evidence. And I give a list of possible evidence. And it's also something that we're going to brainstorm about. So, after we have all of the letters written and all of the evidence, I'll also write the statement. I'll also work in collaboration with your team in order to get the business plan written. I have meetings with your team and everybody in terms of writing the business plan, what we want the business plan to say, how we want to present it, the points we want to make, and every case is unique and different. And then once we have all of the letters, the business plan, and the evidence, then we do that cover letter to immigration and we file. And at this point in time with where we are, you want to file as soon as possible because, as you said, Patrick, the amount of NIW filings has increased substantially. And
I think it's the first year clearing 20,000. It used to be substantially less, and it's like NIW and just perm EB-2 NA cases. NIW and perm cases are like almost equal.
Yeah, almost equal. And again, you'd rather be doing an NIW than a perm. It's better for you. You can, you're not tied to an employer. You can get into the line quicker, etc.
You save about a year.
Yeah, absolutely. But there is a backlog now. So applying for a green card has two parts. part number 1 is the I-140 petition, and that is the national interest waiver. And you can file part 1 at any time. And the filing of part 1 gets you into the waiting line. Then part number 2 is the green card application. If you're already in the United States with a temporary non-immigrant visa, then you're going to file what's called an I-485 application. If you're overseas, then you're going to be applying for an immigrant visa at the US Embassy, and that application goes through what's called the National Visa Center, and it's form DS-260. And there is a backlog right now, both to file the green card application in the United States and then to get the immigrant visa overseas. There's something called the Visa Bulletin that is published by the State Department each month. And there's 2 charts in that Visa Bulletin. There's something called the date for filing chart, which is the date you can file the green card if you're in the US. And then there's something called the final action date chart, which is the date they'll give you the green card in the US or they'll give you the green card at the US Embassy. And those dates are backlogged right now. And the date for filing chart is backlogged 11 months till January 2023. And the final action date chart is back till July 2022. But it's really longer than that because the Visa Bulletin each month is issued and the dates it's not moving. So we don't know exactly how long it's going to take to get the green card. That's beyond everybody's control. But the sooner you file, the sooner you get into the waiting line.
I mean, if you had to give a best estimate, I guess, how long does it take in general, for a typical case, getting the petition together?
It takes about 4 months, give or take, to prepare and file. And then after we file, it takes immigration about 6 months to make a decision. But how long it takes immigration is not relevant. They offer premium processing, but there's no point in using it.
The $2,500.
It's just a waste of money because it's not going to get you the green card any faster. So, what I believe is that it's going to be anywhere from 2 to 3 years, just based on what I read and talk to other lawyers about and see myself. But nobody knows. I mean, there's no human being on earth that can answer the question how long you're going to have to wait for the green card. So we just watch it each month. And again, you just, it is what it is.
And there's some nationalities where I heard the estimate for Indians is 50 years, Chinese over 5 years.
Yeah, I mean, I would hope it's not 50 years, but I've been hearing 50 years for the last 20 years, but I've had people from India get green cards not taking that long. So you really don't know for sure. But yes, India and China are backlogged more than other countries. And because there's a limited number of visas each year, and no one country can have any more than a certain percentage, and the highest demand comes from India and China. So everyone from India and China wants an EB-1, an EB-1A. And if you have an approved NIW, then you're going to eventually get the green card. So at that point, if you want to try an EB-1A, great, right? Who cares if it's not approved? If it gets approved, you're going to save a lot of waiting time.
And for most professionals, like it's worth your fee. If someone's making $250,000, whatever, in tech, it's probably a likely.
It's worth the fees no matter what. It is worth the attorney fee, the visa franchise fee, the business plan fee. You get, you're getting one shot at this, and you're not going to be able to do it as well on your own as you are with professionals. You can, certainly try it, but what was always upsetting to me is when somebody does it on their own and they make a mistake, and their own mistake winds up being the reason for the denial. A classic example of that is you should never have what we call speculative language in letters. Words like potential, promising, may, will, might. Immigration is only giving you a green card if you
to
are
do it.
already accomplished, right? When I talk to researcher clients, I say your research has the potential to cure cancer, but it also has the potential to not cure cancer. So when somebody says your work has potential, that's like, you can't say that. You're asking immigration to deny your case when you do that. And that's where, the professionals are going to make sure that doesn't happen.
And what I meant to, in terms of like the professional fees and everything, you have a pretty unique approach. I guess you're very creative in your approach of how you look at cases, and allowing people to maybe get their green card faster by not just doing the EB-2 NIW, but also doing the EB-1A for pretty
Sure.
similar
So
fee at the end of the day, and get the green
absolutely.
card a lot
If
faster.
we've already done the NIW, Patrick, then everything is in the foundation is in place for an EB1. So then I don't need to charge a full fee to
Yeah.
update in EB1, and because I have this whole team in place that is geared towards this, I can do this a lot more efficiently and faster than a law firm that doesn't. So I don't have to charge as much as some of the other law firms. Sometimes I see fees that are just astronomical, and also they don't care, right? I mean, it's like they're getting paid, and if you get approved or not, oh well, right? But we really
Yeah.
are
I
invested
think it's
in.
unique because there are a lot of firms that charge kind of the same as you, but just researchers, and you have to have like 30 citations. But we tend to see for the STEM and entrepreneurs, a lot of the attorneys are learning the NIW on the fly, where they might have done some E2 visa cases in the past, but that specialty doesn't necessarily translate over to also doing the EB2, and they're kind of learning while their clients go through the process.
Yeah, and again, what the framework is the same. So, we're going to I can prepare an NIW for anybody, any field, anybody. The approach is the same. It's just the letters and the evidence are going to be different. But in the end, it's the same three prongs that everybody has to meet.
And how do you approach RFEs? I know you don't get RFEs at such a high rate, but there might be some cases that the government comes back with a request for further evidence.
Sure. So, we're always trying to avoid the RFE in the first place. I give the full case at the beginning in the hope to not get the RFE, but sometimes it's inevitable. A lot of times with the RFE, the immigration officer has made a mistake. They haven't, fully reviewed the evidence. They're talking about something that's really not applicable. So, we gently tell them that, hey, this is not what this case is about. It does meet the legal standard, etc. And then you have to do more, right? So if you think you've done everything with the initial filing and they give you an RFE, well, now you have to do more. So we have to talk about, well, what additional letters can you get? What did the immigration service ask for, and how do we approach that to try and get the case approved? So you would just have to think about, okay, these are the letters we got initially. Now, what can we do more?
You mentioned earlier, some of the temporary visas like TN, H-1B. What are some ways that for people to come here sooner than 2 to 3 years that they can move to the U.S.?
Sure. So the E2 is an investor visa. So that would be, starting your own business, and that's your forte, your specialty. And so that is, if you have the money to invest, then you can apply for an E2, but you have to be from a treaty country. So there's a list
Yeah.
of treaties from the State Department, and only certain countries are eligible for E2. Short of that, you would need an employer sponsor. So if you're from Canada or Mexico, you have the ability for a TN. If you're from Australia, there's an E3. If you're from Chile or Singapore, there's something called H1B1. But for the most part, you would need to be sponsored in the H-1B lottery unless you were working for what's called a cap exempt H-1B employer, which is basically a university or a nonprofit research or government agency. And then there's something called an L-1B, which is where you have a company in an L-1B or an L-1A. You have a company that you're working overseas, and there's a U.S. corporation that is either a parent, subsidiary, affiliate, or branch. And then you can transfer either as a executive or manager or as a specialized knowledge worker from the U.S. company, from the foreign company to the U.S. company. And there's something called a new office L1, where you could start a new company in the United States. And that's you need a whole business plan to show that you're going to be hiring people. You can't be an executive or a manager unless you have people under you that are carrying out your directives. And
We've
that's
seen a few of
another.
those L1s from our clients from Brazil, South Africa, countries that don't have the E2 visa, where they'll acquire an existing business, existing franchise, and be able to come, get that visa for 3 years while the EB2 NIW runs its course.
Yeah, absolutely. It's all about being creative and trying to make it work within the context of the immigration laws and regulations.
How we always hear I always hear dual intent, non-immigrant visa. How can someone that is in the US but they're going to be out of status, and they want to drive the vehicle themselves and not have to worry on getting sponsorship? How can someone get the E2 visa, invest in a business, and switch maybe from F1 OPT to E2, and then run the course for the EB2 NIW?
Sure. So there is, again, we talked about there's the I-140 and then there's the I-485. So just filing the I-140 petition, that is not a problem with the working visas, with the H-1B, the E-2, the TN, the L-1. Filing an I-140 is not going to prevent you from getting one of those temporary non-immigrant visas. It won't prevent you from getting a visa at the U.S. Embassy, from traveling, from being admitted.
And why is
If you,
that? You're just
it's a quasi dual intent. So there's concepts of intent under the immigration law, and there's different visas. So an F1 visa is a non-immigrant intent visa. A J1 visa is a non-immigrant intent visa. If somebody's on an F or a J and they file an NIW petition, I tell them not to travel outside the United States, because you might not get a visa at the embassy. It would almost certainly be denied. And there's always a risk when you're coming back in at the airport. H-1B and L-1 are full dual intent visas. So even if you're in the US and you file a 485 green card application, you can still travel outside the US and return with the H or L visa. Then there's the in-between ones, and the in-between ones are the TN and the E. So, generally speaking, if you have an I-140 but not a 485, you're not going to have a problem with an E or a TN.
Thanks for clarifying that. And how does the O1 visa fit in all this?
The
Because
O1
that's
is
become a popular category.
right. That's the middle one
Oh,
where,
okay, yes.
if you just have the I-140, there's no problem. But once you file the 485, you can't travel. You can still extend an O1 after filing a 485. You can't do that with a TN, but you can't travel with an O1. And an O1 is another one of those types of non-immigrant visas. That's the non-immigrant equivalent of EB-1A, but it's a much, much easier to be approved for an O1 than an EB-1A. The legal standard's just not as difficult, but you do need an employer sponsor. You could have your own business, have a board of directors, and have that company sponsor you for O1. There's ways to do that, to be creative, but most people, they're either being sponsored by an O1, by a company, or by an agent, like an artist, a journalist. They might have an agent who's sponsoring.
Brian, anything that we haven't discussed today that you think would be relevant to our audience?
Yeah, I mean, everyone's always worried about the political landscape in the United States, right? I mean, we have an election next year, and it's very well possible that Trump is the president again. And I always tell people, don't worry about that, right? I mean, you could there be travel bans on certain countries? I mean, anything is possible, but the general structure of the national interest waiver petition, the visa system, right? That can't be changed by executive order. We are my business kept going when Trump was the president. I had kept getting NIW approved, right? I mean, so just don't worry about the politics of this, right? If you want to come to the United States to live and work, then go for it.
Yeah, I mean, we saw that. I mean, I remember 2016, a lot of our franchise investors were applying for the E2 visa back then, and it was a buy American, hire American, and the business plan had to reflect that. And there were some changes to get the E2 visa, but it wasn't, doom where there was a massive increase in the denials or anything.
Correct, and that's not going to be the case, going forward.
One question from Sandra, Brian. Considerations for maintaining national interest post approval.
Sure. So again, you are telling immigration what your field of work is. So when you're preparing the petition in the first place, you want to define your field of work broadly enough that it covers anything you may do in the future. So that should never be a problem for anybody, because you should eliminate that as a problem from the very beginning, right? Immigration is not telling you what your field is. You are the one telling them what your field is. So just define it in a way that even if you want to change jobs, whatever you were working, you want to be a consultant now, whatever it may be, that however you tell them what you're going to do in the national interest waiver petition is going to cover anything that you think you may do.
And in practice, like, are there checks that the government does to make sure that you're complying with, the
So
basis of why they give approval?
before they issue the green card, right? They could ask you what it is that you're doing, and then it would be after you get the green card. It would be if you want to apply for citizenship. Well, did we give you the green card on day one, and then on day two you went and you were a bartender, right? So they would deny you the citizenship, right? But again, I've never in my entire career had a problem with that because I'm anticipating it from the beginning.
Okay. Well, thanks for that. I mean, we have other questions, but honestly, going through them, they've all been addressed. Brian, thanks. Your wealth of knowledge, and really appreciate all the insights that you share to the wider Visa franchise audience, as well as the work that you do for our current clients and past clients at Visa franchise.
Very good. It was a pleasure, Patrick. Thank you so much for having me today.
Thanks, Brian.